All set.
All right. Good afternoon. I'd like to call this informational forum for the Commission on Judicial Compensation to order. I want to thank you all for taking the time to come this afternoon and to provide comment on this very important topic. And with that, I'd like to move to the presentation of our invited speakers. First on our agenda is the Honorable Rupal Shah, head of the Judges Association, chair of the Judges Association. Judge Shah, you are welcome to begin your remarks. Thank you.
Thank you, Chair Bethken. Good afternoon, Commission members. I'm Rupal Shah, the president of the Connecticut Judges Association. Thank you for inviting me to testify before the Commission today. Thank you also for serving on this Commission. I've worked with many of you previously, and I truly appreciate your time in considering this important issue. I wholeheartedly support the report and recommendations that Chief Justice Mullins has submitted to the Commission. All of the points he makes, and particularly the statistics regarding retention of judges over the last several years, should be particularly concerning to all of us. The judiciary plays a unique and critical role in our democracy to uphold the rule of law. Judges are central to the judiciary. In my 10 years as a judge, I've seen the bench change significantly in terms of judges leaving, retiring early, and morale declining. This job is challenging, and I've not served in a court yet where I've not had to bring my cases home with me at night or on the weekend, far beyond the 9-to-5 description that is mistakenly presumed. With well over half of the judges on the bench having served less than 7 years, it's essential to retain experienced judges in the system for so many reasons, including that they are an invaluable resource to less experienced judges and provide a critical role on the bench, especially with the more complex and difficult cases that we see as judges. There is simply no substitute for the knowledge and wisdom attained by sitting as a judge, and sharing that knowledge and guidance with less experienced colleagues is what strengthens our system and ensures that we all make the best decisions we can to serve the people of Connecticut. In the over 10 years I've been a judge, I've seen too many of our colleagues leaving the bench, not to enjoy their golden years in leisure, but to join a private firm and practice part-time for a higher salary, either as an advocate or a mediator. More competitive judicial compensation is necessary to retain experienced judges. It is also essential to attracting a diverse and talented pool of candidates to the judiciary. For all the foregoing reasons, the Connecticut Judges Association fully supports the recommendations of the Chief Justice as contained in his November 12th submission to this Commission. We encourage the Commission to adopt these recommendations. Setting judicial compensation for fiscal year 2026 in accordance with these recommendations, with future annual adjustments equal to CPIU plus 2%, will help ensure that Connecticut citizens are served by a judiciary made up of a strong mix of new judges from the ranks of highly qualified and accomplished attorneys and more experienced judges. Thank you for your consideration. I'm happy to answer any questions.
Thank you, Judge Shah. Members, does anybody have any questions for Judge Shah? Yes, Member Malshinsky.
Thank you. I just had a question regarding the issue of declining morale. Is compensation, in your opinion, the principal contributing factor to declining morale among the judiciary?
You know, I think all of my colleagues are grateful to have this position and we understand its importance, but I do think compensation is a part of some of the declining morale. I mean, we all have, you know, our various obligations and I guess seeing the statistics on compensation with respect to other positions with the fact that we are now 37th when you factor in CPIU, you know, does play a part. I would not say it was the contributing significant factor, but it definitely is a part of declining morale.
Would you say also that the pension is an issue among the judges, or are people generally satisfied?
I mean, I think we all can agree that the pension is you know, a positive benefit. I think all states account for a pension for state judges. So that does go into the mix, but when you look at the salary, it hasn't even kept up with state employees in terms of cost of living increases.
Thank you.
Thank you.
Any other questions of Judge Shaw?
Aaron, I have a question.
Please go ahead.
Judge Shaw, thank you so much for being here today and giving your presentation. It's highly important for all of us to gather all this information. You mentioned how the concept of a 9-to-5 role is not necessarily accurate here in today's world, and how you often take home materials and your hours expand. On the average for the judges across the state, not just yourself, have you been able to kind of survey or assess some sort of estimate of the number of hours which judges are spending on their caseloads and their work?
You know, I mean, I think there is some variation in the hours, but if I were to approximate 50 to 60, maybe more than that. I mean, it does vary by the court, but just for example, I think over the last few months, I've worked every weekend and at least a couple nights during the week. I've had trials back to back for the last month and will until Christmas. So, you know, if we are going to make the kinds of decisions that lawyers expect of us and the people of Connecticut, then we have to put in the time.
Thank you.
Thank you, Member Noble. Judge Shaw, you talked about that a majority of the bench currently has less than 7 years of service. The number of judges, the authorized number of judges has not increased during that time period. Do you think it's simply that there was periods of time, particularly during fiscal crisis, where there were not a lot of additional appointments to the bench? What do you think is the reason behind, the majority reason behind the lower level of experience in the majority of the bench?
I think it was in the Chief Justice's reports that over, I think the period 2020 to 2023, over 70 judges left to join private practice. I think that's a significant contribution. And of those judges, I think they were more senior.
Thank you. Any further questions of Judge Shaw? Yes, Member Melshinsky.
Yeah, just to pick up on your last point, you know, it used to be unheard of that a judge would leave the bench to go back to private practice. Is it your impression that the principal reason that that's happening now is the compensation issue for judges? Are there other factors involved?
You know, it's hard to know what decision every individual has made, but I think compensation definitely is a factor. I don't know if it's the only factor, but it's definitely a factor. You know, whereas in the past, I think a lot of judges would become JTRs. Now, you know, that's less attractive and they're going back to private practice.
Aaron, can I just make a comment? This is Dan Papermaster.
Absolutely. Thank you, Member.
Hi, Judge Shaw. How are you? It's nice to
Hi.
see you.
It's nice to see you.
I just wanted to make a comment that Judge Shaw and I worked together in the private sector, and she was an excellent lawyer. So I think we're all grateful that she decided to become a judge and serve the public interest. So I just wanted to let everybody know how highly I thought of Judge Shaw.
I appreciate your comments.
Thank you very much. Any further questions or comments? Judge Shaw, thank you very much for your time and for your service on the bench.
Thank you for inviting me to speak.
Our next scheduled speaker is Magistrate Michael Ferguson from the Chief Family, he serves as the Chief Family Support Magistrate. Magistrate Ferguson, I turn it over to you.
All right, thank you. Good afternoon. I would first like to thank you, the Judicial Compensation Commission, for the opportunity to present to you today. It is my honor to speak on behalf of the Family Support Magistrates. My name is Michael L. Ferguson, and I am the Chief Family Support Magistrate, overseeing the administration of the statutorily appointed Family Support Magistrates, as well as the Family Support Magistrate referees. To begin, I would like to present an overview of the important role that the Family Support Magistrates play within the inner workings of the judicial branch. The magistrate program is born out of the statutes and bestows upon the division the distinct responsibility to adjudicate proceedings regarding parentage and support of spouses and children who are recipients of Title 40 services. This includes individuals who receive state assistance and those who apply for support assistance through the Department of Social Services. There are 9 magistrates who cover the entire state of Connecticut, presiding over different locations each day to ensure that all of Connecticut's citizens are provided access to a swift and just resolution of their parentage and support disputes. Notably, a significant number of the parties who come before the magistrates are self-represented. The magistrate program works alongside major state agencies, that being Support Enforcement Services, Department of Social Services, and the Attorney General's office. This increases both the volume of persons that come before the magistrate each day and the responsibility associated with managing dockets involving many conflicting interests and points of view. In short, the magistrates are devoted public service from various backgrounds who have a crucial role. They hear thousands of petitions and post-judgment motions each year. Family Support Magistrates serve a term of 5 years. They are appointed by the governor after being interviewed by the Governor's Council, are presented to the Judiciary Committee for questioning at a public hearing, and are thereafter confirmed by the House and Senate in a process which is substantially similar to that of Superior Court judges. Dissimilar to small claims magistrates, probate judges, and motor vehicle magistrates, and pursuant to the Connecticut General Statutes, the Family Support Magistrates, similar to judges, must devote full time to their duties, and is not permitted to otherwise engage in the private practice of law. I've reviewed Chief Justice Raheem Mullen's proposal as it relates to a salary adjustment for the Family Support Magistrates. It proposes modest and fair increases in the Family Support Magistrate's salary at an equivalent percentage to that of a Superior Court judge. Notably, Justice Mullen's proposal calls for an adoption by the General Assembly of a statute that would provide for these increases and continuing onward to ensure that pay levels are set regularly and are based on fair and objective benchmarks. Overall, the proposal is thoughtful, carefully crafted, and fair. I support Justice Mullen's submission. I hope that you adopt his recommendations. Thank you again for your time and thoughtful consideration of my testimony. I will be happy to answer any questions you may have.
Thank you very much, Magistrate Ferguson. Does anybody have any questions for Magistrate Ferguson? All right, Magistrate Ferguson, thank you very much for your time, for taking the time to come before the commission today.
And thank you for having me.
Take care. Thank you. Our next scheduled speaker is, or invited speaker is O'Donovan Murphy, the Director of the Judicial Marshal Services.
Mr. Murphy's having trouble logging in. Can we go to the next speaker and come back to him? Is that okay?
Certainly. Thank you very much, Kat. The next speaker, invited speaker, is James Sheeran, head of the Connecticut Bar Association. Mr. Sheeran, you have the floor.
Good afternoon, Commission, and thank you for your service. The Bar Association supports the recommendations made by the Chief Justice.
Could you
Judge
speak
Shaw.
up a little bit, sir?
I'm sorry. Is better? Thank you. I was thanking the commission members for their service. I also want to say that the Bar Association supports the recommendation made by the Chief Justice, largely for the reasons mentioned by Judge Shaw. But perhaps I can give a little perspective for those of you who are practicing day to day in the profession. The current salary for a Superior Court judge is probably on the order of $25,000 and $30,000 higher than what a first-year associate is paid at Connecticut's larger law firms. So you're taking what should be the best of our talent on the bench, and comparably, it's essentially what a third or fourth year associate would be paid, and less than what an associate in Boston or New York City would be paid. So you've got an attraction problem if you don't increase compensation. You've got a retainage problem as well. When those, as Judge Shaw mentioned, those senior judges come to a point where they can attract a higher compensation towards the end of their career, in addition to sometimes what their pension might be. So it's a critical problem. We're not getting the best talent we should be getting, and we're not retaining the best talent that we should be retaining. So for those reasons, I support the Chief Justice's recommendations. I'm happy to answer the question about that.
Thank you, Attorney Sharon. Does anybody have any questions for Attorney Sharon?
Aaron, I have a question, if I may.
Yes, thank you, Mr. Noble.
Again, thank you, Attorney Sharon, for being here today and presenting us with some information. I am interested, though, in whether the CBA has any data concerning the salaries and incomes for medium-sized law firms and smaller law firms, not just the larger law firms in Connecticut.
Well, the Bar Association doesn't have that information. Anecdotally, I have a clear understanding of that information. Judge Steve Nelson might have a even better understanding, since she's got a bunch of students who leave school every year and move to some of those firms. I would say that at the mid-sized firms, you're probably talking the order of $110,000 for a starting salary. Smaller firms are harder to judge because they may be boutique firms, personal injury firms, so I don't have a understanding of it.
I appreciate that. Thank you so much.
You're welcome. Mr. Horowitz's hand is up.
Hello, Attorney Sharon. How are you?
Good, Jim. How are you?
Good, thank you. Tim, I'm sorry, I missed the beginning of Judge Shaw's comments, but I mean, obviously there is a huge attraction and retention issue, and from your comments, it sounds like that is largely a compensation issue. And I'm just wondering, years ago when you and I were younger lawyers, that attraction and retention issue did not seem to be as great an issue. And I'm just wondering, have we lagged, or is there something else going on that we're not grasping?
Yeah, there may be other issues, Attorney Horowitz, that are motivating people to leave the bench or not to find it as quickly as people of our generation may have. I think compensation is probably the most important factor. And when you turn back time, when there wasn't that gross disparity between what a judge was making and what he or she could afford with what he or she was making, especially in juxtaposition to what a younger associate was making, that disparity has become more profound. And the ability of a judge to sustain the life that he or she would like to sustain, having gone to school for 19 years, has become obviously not perhaps what they thought it might have been. I will confess that my firm has hired 4 or 5 of the retiring judges. We have a robust mediation practice. There is a there is a life after being a judge that can be very financially rewarding. I don't know that those judges have left the bench because of that. But I know there's no shortage of people who call me looking for opportunity.
And that's certainly a phenomenon that didn't exist 10, 15 years ago. The whole post-bench mediation
Yeah, that
gig.
did not, and I'm not sure if everyone on this call is aware of it, but there are probably 6 or 7 different outlets, including law firms, that now have mediation practices, often anchored by a judge or judges.
Thank you.
You're welcome.
Thank you, Attorney Horowitz. Any further questions of Attorney Sheeran? Thank you very much, Attorney Sheeran, on behalf of
Thank you.
for taking the time to talk to us today.
Appreciate it.
I believe that I saw O'Donovan Murphy online, so we'll go back to Mr. Murphy. He's the Director of Marshal Services. Mr. Murphy, you have the microphone.
Good afternoon, and sorry, I was having technical difficulties there. Showed up as Melissa Farley, which I'm certainly not. Good afternoon. My name is O'Donovan Murphy. I'm the Director of Marshal Services. I'm responsible for the courthouse security as well as the security of the judges in the state of Connecticut. I'm here today to address a concerning trend, the significant increases to threats directed at our judges over the past several years. While judges are inherently vulnerable to public scrutiny and unfortunately retaliation, what we observed is an alarming escalation in the number of threats against judicial officers both on and off the bench. These threats range from verbal harassment to more direct and sometimes violent intentions. Some of these threats are delivered through phone calls, emails, social media platforms, while others come in the form of letters, phone messages, or even personal confrontation. This uptick in the threats is not limited to high-profile cases, but extends to all levels of the judiciary. Whether related to criminal matters, family disputes, or civil cases, judges are becoming targets for individuals who may disagree with the ruling or feel aggrieved by the decisions of the court. The emotional intensity of some litigants, paired with increasing polarization in society, has contributed to a growing danger nationally in Connecticut and across the country. The safety of our judges is paramount, not only to protect the individuals who serve the critical role, but also to ensure that our courts can continue to operate without fear or interruption. Threats against judges are ongoing attempts to undermine the integrity of the judicial system and jeopardize public trust in the rule of law. In response, the Marshal Service, we have implemented enhanced security measures, including the recent development of the Office of Protective Intelligence. We've improved our surveillance security and increased coordination with local law enforcement. Judicial marshals are consistently exploring ways to provide our training for our marshals to recognize threats easier. However, judges continue to be threatened at an alarming rate. It's increased by 31% over the past 2 years. And I'm open to any questions you may have.
Thank you very much, Mr. Murphy, Director Murphy. Anybody have any questions for Mr. Murphy? Yes, Attorney Horowitz, Member Horowitz.
Thank you, Mr. Murphy, for your comments. Have you taken a look at whether whether the threats are in particular portions of the judiciary, for example, are domestic judges more at risk than civil judges, criminal judges more at risk than? You understand my question? I'm just trying to understand whether there's any kind of delineation in the data.
Yes, I think there's a higher rate of threats against judges that are sitting on family matters.
And back a long time ago, when I was a young lawyer, there were marshals. There were many, many more marshals, and there were marshals in every single courtroom, full time. And over time that's diminished. do we need more marshals? Do we need more marshals in the domestic courts? What's your sense there?
Yes, we're short-staffed and we're struggling to obtain marshals. There's a shortage of interest in law enforcement across the country, and we struggle. A lot of times we go through great lengths to recruit marshals, and then they leave to go to municipalities or the state police. So we do have a transient group of younger marshals that we seem to struggle to retain. I know this year we're scheduled to have 6 classes. It's not for a lack of effort of putting the classes together. It's a lack of a qualified pool of applicants to start off with, and then being able to retain those marshals.
And lastly, and I'll turn it over to others. Do you have any the last speakers that we had? I know you weren't here for them. In fact, I missed part of the comments as well. But there's a question of retention of judges. And I know that often marshals have an opportunity to speak with judges kind of off the record. Do you have any sense anecdotally as to whether the increased threats that you're describing are affecting judges' willingness, desire to remain on the bench?
I believe overall, yes, it does have an impact, I think, across the board with the judges. I know when I first started, judges never left. I don't know what the other speakers spoke on. But when I started in 1988, it would be rare for a judge to leave. And now I've seen judges leave to take other jobs, yes.
Thank you, Mr. Murphy.
Are there any other questions for Mr. Murphy? Thank you very much, Mr. Murphy. Appreciate you taking the time to present to the panel today.
Thank you.
The next speaker on our list is Attorney Glenn Coffin from the Connecticut Defense Lawyers Association. Attorney Coffin, you have the floor.
Good afternoon. Thank you very much for allowing me to speak briefly. I'm the current president of the Connecticut Defense Lawyers Association. And again, I appreciate this important opportunity to speak on an important issue. Judges play an indispensable role in the administration of justice. They're the gatekeepers, and their importance in these roles in legal disputes, civil, criminal, and otherwise, can't be understated. The need to compensate judges appropriately so as to attract attorneys to these important roles and to retain them and their experience as they progress through their career cannot be understated. The CDLA has reviewed the Chief Justice's report and the associated recommendations and supports them. It's in the best interest of the judiciary, the bar, and the general public to attract well-qualified attorneys to serve in such a crucial role. And we're happy to answer any questions or comment or assist in the process moving forward. Thank you so much, and happy holidays to everybody.
Thank you very much, Attorney Coffin. Does anybody have any questions for Attorney Coffin? Thank you very much for your time.
Thank you.
And our last scheduled speaker is Attorney Eleanor Sterling from the Connecticut Trial Lawyers Association. My apologies on the name. You have the floor.
That's fine, Madam Chair. Thank you. So, Madam Chair, members of the committee, thank you so much for your work on this critically important issue. My name is Eleanor Sterling. I'm here on behalf of the Connecticut Trial Lawyers Association to support Chief Justice Mullen's proposal regarding judicial compensation. Just briefly, the Connecticut Trial Lawyers Association is an organization of lawyers with approximately 1,200 members who represent injured individuals, individuals who have suffered workplace discrimination and harassment, injured workers, and the lawyer members of the organization are in Connecticut's courts as often as we can be. So compensation and of our judiciary, but also the quality of our judiciary is critically important. CTLA's mission is to protect the individuals we represent and the individuals who will be represented in the future through fair laws and access to justice. And we recognize that the quality of our judiciary is so important in what determines access to justice. So as a lawyer who has stood in a courtroom beside a client, as I know many, many folks on the commission have, and had a decision come down, whether it be good or bad, the way that that decision comes down, the experience, the fairness, the thoroughness of the judge who hands it down, shapes the experience of justice that that person has. I've seen it happen over and over again, and I'm sure you all have too. Even if it's a negative or disappointing decision, when it's handed down in a compassionate way from an experienced judge, that matters so much. So I'm here to say that we believe that recruiting judges, recruiting quality judges, recruiting diverse judges is so important to support access to justice, that retaining judges is just as important. It's important both to the clients we represent, to the lawyers who work in the system, but also to the other judges coming up through the system who learn from those experienced judges. It's been hard for us to watch the loss of senior judges, and particularly because those senior judges are really important to the trial practice. To when you have a case that's going to be a jury trial, it's really important that you have a judge who has some sense of how that process is going to play out. So as I say, we support Chief Justice Mullen's proposal. I feel that it is moderate almost in the extreme. Justice Mullen's proposal would put Connecticut at the median among the states that were surveyed. So meaning that it would be 26th, we would be 26th of 51. But when you consider cost of living in Connecticut, that still doesn't bring our judges to quite where they could be. So we're fully in support, but I do think that as you think about the proposal, putting us at the median is really the bare minimum that we can do. Commissioner Noble had a question about compensation in smaller firms. So I can't speak to that systemically, but there was a part of the Chief Justice's proposal. He did a PowerPoint that is on your website, and I was directed to it earlier today under the November 12th tab. And there is some information there about compensation for firms with 100 or fewer lawyers. So you may have already seen about that, but that's what I thought might be responsive to your question. There it says that a first-year associate in a firm of 100 lawyers or fewer makes $155,000. And then there was also an interchange between Commissioner Horwitz and Attorney Sheeran about judges becoming mediators. And my thought in response to that interchange was judges can mediate on the bench. So if a judge is really enjoying doing mediation, there are some opportunities to do a lot of mediation on the bench, which indicates to me that when judges leave to go to a mediation practice, I would expect that part of the allure of that is the higher compensation in private practice. I'd be happy to answer any questions.
Does anybody have any questions for Attorney Sterling?
Aaron, one question very quickly. Attorney Sterling, it's good to see you. Thank you for your testimony today. I think you would probably agree with me that having judges on the Superior Court who come from a background of having trial experience is important. What can you tell us, even anecdotally, about your membership's interest in getting onto the bench? Is it declining because of pay issues or other issues, or is it steady? What can you share, if anything, on that score?
Nice to see you too. All I can share is anecdotal. And let me explain a little bit of why, although you may all already understand it. For an attorney in private practice, to decide that they're going to go on the bench, once they are open about that decision, it has all kinds of impact on their practice. So, and for someone who is not sure they'll make it through judicial selection, who is not sure that they will get the nod, there are a lot of reasons to keep that information very close to the vest. So that's why I say that the information I have is anecdotal. But with that information, I would say that even though we have been emphasizing to our members how important it is to apply to be on the bench, and we actually just had a presentation at our last annual meeting about this. There are folks who are through judicial selection who are holding on moving forward. I would say that there are reasons to stay in private practice. So I think that's as much of an answer as I can give you.
Thank you.
Any other questions for Attorney Sterling? Thank you very much, Attorney Sterling, for your time and for your presentation today.
Thank you.
Kat, do we have anybody who has popped up for public speaking today?
We do not.
Okay, thank you. Is OFA available at this point?
Hi, Rob Weissack, OFA is available. One sec. We just have to pull up the presentation.
I'm going to share the screen. Oh, I sent a request to share the screen.
Give us a minute. I'm sure we're working on it.
I hit allow, so there we go.
When
Everybody see the
there we
screen?
go.
Yes,
Okay.
that's great.
Okay. Just say, you ready, Rob?
I am ready.
Okay.
Hi, my name is Rob Weissack. I'm from the Office of Fiscal Analysis. And we were asked by the commission to kind of give a brief overview of kind of the state of fiscal affairs right now. Our office just completed what is a mandated report per statute. It's called a Fiscal Accountability Report, where we're required and the Office of Policy and Management are required to provide certain fiscal forecasting and fiscal data according to the statutory guidelines. So one of the things I want to point out before we get to the slides is that because of the statutory limitations, this is not an all-encompassing forecast. What the statute requires us to do is forecast based on a defined basket of fixed costs that can vary from year to year, and that the non-fixed costs are supposed to stay essentially unchanged or flat. So the numbers I'm going to give you are under that premise. But there is another slide that will kind of present some other considerations in context of those numbers. So with that, we can get started on it. So the first slide is kind of a snapshot of where the current fiscal year, which runs from July 1st of 2024 to June 30th of 2025, what we call fiscal year 25. And when the legislature enacted the budget way back 2 years ago, at the time, when we marked forecasted revenue versus what was appropriated in the budget, net appropriations, there was a determined or built-in budget balance of about $298 million. Since that time, we have gone through a couple of consensus revenue updates. OFA and OPM per statute have to attempt, which we always have, provide the legislature and the governor with one set of consensus revenue estimates for the year that we're in when we do in November. And then for January, that forms the basis of the budget looking forward that the governor has to use. And then April, those are the final numbers that the legislature and then ultimately governor signs off for on a budget. So we've gone through two iterations of consensus updates. The first one saw a small increase of like $25 million in April. And then this past November, we saw a net increase of $250 million. And you can see the components there. Withholding, E&F stands for estimates and finals. PET stands for pass-through entity tax. But there are some statutory limitations on the use of revenue. So you see this volatility adjustment of minus 240 is money that was backed out that is not available to balance or to mark against the 25 budget. And you can see the other forms of taxes and revenue, the pluses and minuses that make up the 250. We started with budgeted expenditures of $22.8 billion in change. We've identified some accounts that are going to not spend to their appropriation of about $95 million. And then we've identified deficiencies in accounts that are going to that are anticipated to spend over their appropriated level. And then there are some technical adjustments that we have to make to marry up with some statutory requirements. So when we add all the pluses and minuses together on both the revenue and expenditure side, we come up with a new revised balance, surplus or deficit, if the fiscal year ended this way and the comptroller certified, of $122.7 million. So you can see that there has been an erosion of the original balance to what we see today, and that's largely driven by the deficiencies are outpacing the revenue increases. Basically, that 487 plus the other almost $60 million marked against the almost the $275 million worth of revenue. So while the fiscal year is still in balance on an operational standpoint, our balance it looks a little bit smaller than it did when when the legislature originally enacted the budget. So this is just a bar chart of the components that made up that last chart. You can see the lapses, what they're made up of. The largest one being debt service at about $50 million. And then there's some smaller lapses that we're anticipating that make up that $95 million. Of the deficiencies, the largest one is in our Medicaid account that amounts to about $225 million of overruns in that account. This is kind of a continuation of a trend where we're seeing post-pandemic cost and caseload trends in the Medicaid program upticking as people have gone back to their medical providers after the pandemic. We're seeing the upticks even above and beyond what we originally were anticipating. There were some built-in increases, but the trends continue to be above even those benchmarks. We have some other accounts where, because the legislature did not update the 25 budget in the last session, there were some updates to pension and health benefits that were not incorporated into a revised budget. So those are being reflected here as commitments that need to be paid for on an ongoing basis. And then we just have some other technical that are some unallocated lapses. In the back of the budget, the executive branch is charged with finding some money, which historically they typically do find, but since this was a point in time estimate and there hasn't been an identification of those, they're kind of held right now as a technical adjustment that, as the fiscal year continues, there's a hope that there will be more savings discovered as we get closer to the end of the fiscal year. So in conjunction with the current year, the fiscal accountability, the FAR, which that's what that stands for. I talked about the methodology previously, where the methodology allows fixed costs to grow, but the non-fixed costs stay constant. And so the fixed costs here are growing from 25 to 26 by about $250 million. They will grow an additional 273 from 26 to 27, and then an additional 249 from 27 to 28. Like I said, the other non-fixed costs stay flat. And those would include like personal services costs, aid to municipalities, any programs within state agencies that are not considered entitlements. Entitlements are considered fixed cost. Debt service is considered fixed cost. Our fringe benefit, our health and pension costs are considered fixed cost. And some entitlements, certainly Medicaid and some other social service programs that their recipients are entitled to. So when we use that methodology, we see that we have positive balances in 26, 27, and 28, and they are growing. And that's essentially saying is that our projected growth in revenue year over year is outpacing our growth in fixed costs, which is a good thing. There have been years in the past where that was not the case, where our fixed cost growth in pension and health and Medicaid and some other entitlements were outpacing our revenue growth. And we saw large projected negative balance forecasts, which pose a lot of challenges to both the governor and the legislature when crafting a budget for the next 2-year cycle. But in this case, that they have some cushion, and you can go to the next slide. Oh, this just shows the walkthrough of what I did there. This kind of shows the blue line is the revenue projections, and you can see versus that light blue line, which is the expenditures, and you see the gap in between is widening. And like I said, showing that our revenue growth is outpacing our fixed cost growth. So all that news is met with some caveats, and we're going to try to outline some of the caveats here that we'd like to provide a little bit of a caution and warning to people that read our report and you folks that are making deliberations on possibly judges' compensation. Like I said, the methodology has limitations, and we have to abide by those limitations when we're doing our forecast. But there are multiple things that are going to cause fiscal pressures to the next state budget. The first thing would be what it's called our fiscal guardrails. We have a constitutional spending cap that limits the amount that can be appropriated each and every year by a formula. And that always puts, or I shouldn't say always, it traditionally has put pressure on the expenditure side because of that cap and the legislature's inability to go beyond what the spending cap calculation allows for growth in our state expenditures that are appropriated. There are two other guardrails that come into play. In 2017, the legislature and the governor signed two additional caps. One is a revenue cap and one is a volatility cap. And I won't get too much into the details about them, but they both basically act as limitations on the amount of revenue that can be appropriated and spent. So those caps also exert pressure in that not all of the revenue that the state collects can be budgeted and spent. So those caps are certainly going to be, I think, topics of conversation when the legislature reconvenes this session. And they're certainly going to be subject to taking a look at possibly modifying them. But at this point in time, that the caps are in place, so they will exert some pressure on the budget. Growth in non-fixed costs. So one example that we identify or have identified is that our educational cost sharing formula pursuant to what the legislature and the governor has passed is expected to grow by approximately $91.7 million next year. So the numbers that I presented to you before, because of the limits in the methodology, do not include that $92 million in FY26. So, the legislature, the governor and the legislature would have to modify the statute and cancel out that proposed increase in order for it not to happen. So absent that, we've identified at least $92 million here that will have to be added to the 26 budget to satisfy that law. Then there are some expiring temporary transfers that are going to cause some issues with those funds, and there will probably be some calls to continue those transfers, but the numbers we gave on the revenue side do not anticipate that action. That is action that the legislature would have to take to maintain these transfers. But since they involve something that's near and dear to all legislators' hearts, municipal aid, this 104.9 will be a subject of where that revenue will to keep that. And so in order to keep the grants that the state has sent out this year, that would need to be maintained if they want to maintain that level of grant commitment to municipalities. There's also a $10.3 million in cannabis regulatory that will need to probably be transferred to, because that supports the regulatory activities of various agencies led primarily by DCP that regulate that industry. There is also expiring American Rescue Plan Act funds and some carry forward money. Carry forwards are unspent from 1 year. They are not they do not lapse, and the legislature decides to carry those funds forward for a specific purpose in the following year. So they're treated as one-time revenue or one-time resources. So if you're funding an ongoing program with those one-time resources, which sometimes happens, there will be pressure on the budget to replace those one-time resources with general fund resources. And same thing with ARPA. The ARPA program is winding down. Commitments, I think, have to be finalized by the end of this month. And like the carry forward funding, the ARPA dollars are temporary in nature. So if there are ongoing programs that were used to were funded by ARPA dollars, this will also put some pressure on the general fund to replace the ARPA dollars with general fund dollars. Last but not least, the state employee bargaining coalition contract on wages and salaries is expiring at the end of this fiscal year. And so there will be an anticipation that there will be a new contract that will begin in FY26, and that will put some additional pressures on the budget, depending on the scope of that contract and what it shapes out to be. We can tell you that if the contract had similar pattern as the last contract, we're looking at anywhere between 130 to 140 million or $50 million in additional requirements that would be necessary in FY26, and then another 130 to 150 in FY27. But we are not purview to those negotiations between the executive branch and the unions that make up the coalition. So we don't know exactly what they're going to look like, but we've kind of surmised that if a pattern looks similar to what it was the last time, this is what the fiscal impact would be to the general fund. So when you add all of those things up, they are going to definitely eat up a large portion, if not all of those balances that I presented on the previous pages for FY26 and 27. And that's why the fiscal guardrails will be probably a topic of very of debate and scrutiny as to how those might possibly be modified, if modified at all. Next slide. And that's kind of a quick overview of the current year, and then some information on what the legislature and the governor will be faced with for the upcoming session for FY26 and 27. And I'd be happy to answer any questions that the commission may have.
Thank you, Rob and Brianna. If you could leave the PowerPoint up in case people have questions on it, it would be great. Rob, if I may, if I understood you correctly, so going back to the slide, yes, that one, Brianna, number 5. Slide 5 again. Oh.
Wait a minute, we're just
that one, yes.
Yes.
So the projected revenue and expenditures. So what you're saying, if I understood the sort of caveats that you're providing to us afterwards, is that there are a lot of unknowns out there in terms of either legislative action that may be required, the ARPA money expiring and the CBAC wages. So the expenditures do not account for, do the expenditures that you're projecting for 26, 27, 28, knowing that those collective bargaining agreements are standing out there, for example, is there a placeholder in this? In these numbers?
Those numbers that you see right there are absent any of those issues that are on the next slide, the CBAC or ARPA or the carry forwards or any adjustments to anything that pertains to non-fixed costs.
Okay.
So that's why, you know, just taking these numbers without those caveats is something that we didn't want to leave you all with. And we have a presentation to the legislature next week that we certainly will emphasize that the numbers, while they look promising from here, do not include everything that possibly they need to include or should, but we are limited by what we can present based on the language that is in the statute when it comes to developing this report. So we used the next slide to kind of say, hey, this is what the numbers, some of the examples of what the numbers don't include.
Okay, thank you. And last question from my perspective, the numbers that are in the expenditure graph, are those at the, as it stands now, projected spending cap?
So I think that those numbers are all under the spending cap right now. If you were to mark this, if you were to calculate the cap versus those numbers, it would be under the cap. But once we fold in, you know, what will be, you know, a full budget and policy initiatives and adjustments that need to be made, like we said, maybe for CBAC, maybe, you know, for ECS, maybe for some other things, that's when the cap will really kind of, you know, be in play from an expenditure side. So there, like we've said, there's some limitations to the way that we have to present this report. There has been some talk about modifying it, but we don't, you know, the expenditures are only growing by non-fixed costs. Some of them are uncapped, like debt service. So these numbers would, I think, be well under the spending cap as if it was calculated against these numbers.
Thank you. And I said last question, but I have one more.
Sure.
The expenditures that you were showing is about 6 months into the current fiscal year for fiscal year 25.
Yes.
And the deficits were fairly, or deficiencies were fairly significant in the $500 million range.
Yes.
With a surplus of only 122.7. Are there steps being taken to keep the budget in line? And do you expect those deficiencies to hold steady for the next 6 months?
Well, we hope that our projections are right. I mean, we try to project to the end of the year. You know, what we can't predict is, you know, we're in the legislature. We're not, we don't have direct influence over what is spent and what is not spent. But I can tell you that the OPM secretary has sent out a letter to the agency saying, hey, watch your spending, and hey, we are going to start to, you're going to have to start to seek approval for certain position refills between now and the end of the year for us to try to close some of these, some of the deficiency gaps and to identify some of the program lapses that were built into the budget. So I can tell you that the executive branch is taking steps to, if you want to call it, make sure that the budget ends the year, it either balanced or with a small surplus.
Thank you. Do members of the committee have any questions for Mr. Wysock?
Go ahead.
I do. Jim Horowitz, Mr. Wysack, so nice to meet you.
Nice to meet you too.
You can take down the PowerPoint. I don't need it for my questions. Mr. Wysack, I'm new to all of this, but so I understand you're working for the legislative branch. That's your.
Yes, correct. So my office is a nonpartisan office. We work for our bosses or our customers are the 187 legislators. So we work with both Republicans, Democrats, the House and the Senate, and one of our primary roles is to help them develop the state budget. Once the governor provides the legislature with his blueprint, we take that, or the legislature takes that, and we provide technical assistance to the legislature in helping them go through that budget, examine that budget, and then any proposals that they want costed out, we help them with that. And then we are kind of the, if you want to call it the nuts and bolts, or behind that, we keep everything into a system, and we are, charged with making sure that the legislature is not spending more than they have to spend, or that they don't spend over the spending cap, the constitutionally mandated spending cap. So that's just some of our roles within the budgetary process.
Thank you. That's very helpful for me. Our charge, of course, is judicial compensation, and the analysis that you've been providing to us, it feels like that's more of a 60,000 foot or the 80,000 foot level, whereas our charge is more specifically related to judicial compensation. And in the data that you do you have anything that relates to how much we are currently spending on judicial compensation, and were we to adopt the Chief Justice's recommendation, what that would cost, or if we were to embrace what Attorney Sterling was urging us to do, which is to let's really attract quality judges for long periods of time. Has there been any financial analysis that you can provide to us, or is that somebody else who would be the person that we should be talking to for that?
I haven't seen your plans. We certainly could provide the commission on how much judges are compensated. I know in the past, I believe we have assisted in providing some estimates or verifying some estimates that the commission has come up with, I think, or at least when if it does make it into the governor's budget, or if it's under consideration by the legislature, we have provided guidance to the legislature on how much a compensation package will cost in the years that it's in effect for. So we could certainly, I think, assist in that manner if we're asked.
Got it. And I know that during the course of your presentation, one of the things that you were talking about was the pension and health benefits. When I think of judicial compensation, I think not only of the salary, but I think of the pension and health benefits as well. Do those two things, the actual salary and the pension and health benefits, is that the same bucket, the same lines, or are those two different lines that we would be dealing with judicial compensation, and all pension health benefits is, the whole, anybody who's an employee of the state of Connecticut?
So judicial compensation, specifically wages and salaries of judges, is in judicial's operating budget. That's where the dollars are appropriated to pay judges from. The fringe benefits, health and pension, are not budgeted within judicial's budget. They are, for the most part, budgeted centrally. and the Office of the State Comptroller's budget. The Office of State Comptroller is, along with the State Treasurer, is responsible for the management of our pension systems, including the judge's pension. And then the comptroller is responsible for the procurement and the operation of state employee, which includes judges, health package, and retirees health package. So those are centrally budgeted within the Office of the State Comptroller. Judges pension, and then both state employee, retiree, and active health insurance. So
Go ahead, I'll say it.
if your question was, am I seeing a full picture of all that makes up the judge's compensation in judicial's budget? The answer would be no. You would only see the wages and salary piece of that in judicial's budget. You'd have to look elsewhere for the other pieces. Healthcare would be a little tricky to tease out, but judicial pension is a separate line item within the comptroller's fringe benefit line, which we pay for what's called the normal cost, which is an additional year that judges have earned towards credit, and then also the unfunded liability portion of the system, which is, if you want to call it, paying for past service liability that we did not fully fund previously.
And maybe this isn't a question for you, and it's a question for when we go back into our session. But do you know, or Chairman Buffkin, do you know whether, and again, if this isn't the right time to ask this, just be quiet and I'm happy to do so. Is our charge limited to just the compensation, or are we, when we think of compensation as part of our charge, can we also think about making adjustments on the benefit side? And I just put that out there now, and maybe that's for future discussion.
And I think it is for a future discussion, but I would say that in terms of if we're looking at the overall picture and the factors, I think the pension and healthcare come into play, but I don't think that they are compensation as the statute contemplated.
Thank you, Mr. Weissach.
No problem.
Are there any other questions for Mr. Weissach?
Mr. Weissach, I have a quick question for you. We're being asked to consider a growth factor of CPI plus 2% on future salaries. Are there, from your vantage point of looking over the entire budget, are there other salaries that have that kind of growth factor built into them, or how is the growth factor for salary increases usually determined?
So the lion's share of the salaries and wages that is budgeted is unionized employees, that executive branch unionized employees that are negotiated between the coalition that makes up about 36 different bargaining units and the state. So they bargain for wage increases separately. I can't tell you what they use that each side uses. Certainly, they're probably using some kind of CPI as an argument as to why salaries and wages should increase, but I'm not purview to that. The only other thing I can think of is that a couple of years ago, I think for legislators and I don't know if, and the constitutional officers, they now have a formula in which their salaries increase, and it is a CPI index. I'm not sure which one is used, and I'm not sure if there's a plus factor to it. I can certainly get back to you on that, but I think this new legislature will be under that new formulary.
Yes, could you get back to us on that? I think that would be helpful for me.
Sure, we can email the committee administrator on that.
Thank you very much, Rob.
I do have one other question if nobody else does.
Go ahead, Attorney Horowitz.
Mr. Weisach, when we look at the budget for judicial compensation, is the number that would be in the numbers that you would present to us, is that the actual number that's spent on the judges that we currently have on the bench, or is that a number based upon some more abstract number as to what the desired number of judges is to be on the bench? My question makes sense. So let's say we said we should have 150 judges in the state of Connecticut, but we only have 120 judges. What's the number that's in the budget? Is it 120 times the salary or 150?
So the actuals will be what was actually spent. What is budgeted? You have to remember that the judge's compensation is one piece, probably a big piece of all the compensation that's paid out by the judicial branch. You have clerks, you have the courtroom security. So that's just one piece of it. So judicial is getting, if you want to call it, a lump sum or a block of money to pay for all of their wages and salaries that for all of their employees that are under their purview. So it's a number that is budgeted based on current enrollment, and then a lot of times there will be some turnover, and then a lot of times there will be also a factor of new hires factored in to make up that total number. What I'm trying to say is that it's not an exact science in how their personal services line, that's what it's called, is calculated for the next 2 years going forward. So, the judicial typically has had ample money in their budget to pay wages and salaries, given the ebbs and flows of people that are working for the judicial branch as they come on, or as the governor announces new judges or replacement judges. They typically, sometimes there might be some adjustments that are needed in the second year to accommodate for new hirings. So part of it is known and part of it is variable.
Thank you. That's helpful. Thank you.
Sure.
Are there any other questions for Mr. Weisach? Thank you both very much for your time, Rob and Brianna, for providing the information today. Will you share your PowerPoint presentation with the committee administrator so that we can have it to the members?
Sure.
Thank you.
All right. And we'll get back to you, along with sharing that, we'll get back to you with the question that one of the members asked about wages or increases tied to some CPI. I know that the legislature has it. I just don't know the exact formula.
Thank you very much.
Sure.
Turning back to our agenda, I have it up. It's now discussion of, and I apologize if there's a little bit of a background noise. I moved to my new office today with the State University system, and the heat is pouring out of the radiators here. And so the window is open in order to make my office bearable. So I apologize if you hear a little bit of rattling of the shades in that. Otherwise, I would be sitting outside with my computer because it's too hot. So I appreciate your patience. Which is discussion of the recommendations and the drafting of the report. Why don't we open the floor thoughts after our speakers this afternoon? Anybody want to jump in? I'm happy to start us off. I think the information confirmed what was in or supplemented what was in the Chief Justice's report to us in terms of some of what the bench is feeling and the external pressures on the bench. With regard to things like threats to their safety, I know that, you know, from my perspective, that's something that's important to know because these are difficult jobs, but it really isn't, I think, a factor to be considered in setting compensation, unlike what you would do for somebody who was in a hazardous duty position. It's certainly an issue with regard to attracting and retaining, but not necessarily a factor in what that level of compensation should be, from my perspective.
Karen, I agree with that. And I think there are some, unless I've missed it along the way, I think there are some holes in the information here. For example, we're told in the Chief Justice report about 70 folks leaving the bench. It's hard to understand that without that being put in kind of relative historical context. I don't know if that's something that we can maybe ask Judicial to help us with. I also, as far as attracting, I mean, I know only anecdotally that I don't have the impression that the number of people who are putting themselves up for consideration at judicial selection has deteriorated substantially over time. I mean, that may be something that we might be able to fill in. And then I thought that OFA's presentation was really helpful. Unfortunately, I think we come away with there is a surplus on paper, but that may disappear because of how fiscal guardrails are put into play or whether they're modified and whether some other ECS spending or CBAC bargaining outcomes are, how those land. So I mean, I don't, unfortunately, I'm not sure there are, maybe folks on the committee have a good idea about how we can maybe address that last point. I don't, because I think it's a big kind of let's wait and see on affordability, which is, I think, a very significant factor for us.
Perry, to that point, Karen, do we know what they put in for Judicial in terms of, have they proposed paying an increase in salaries to the judges? Or have they submitted a full complement? To somebody's question earlier, do you just put in the actual number or how many are budgeted?
I think that's often a discussion with how many are necessary. It's a discussion between the governor's office and the branch as to how many vacancies there are and what the impact to their budget in place is. I can ask Melissa Farley to provide us information as to whether or not I think they budget for some amount, like they know who's going to retire, like who's going to hit the age of 70. And so they know at what point they'll fall off the payroll, if you will, for lack of a better way to put it, and whether
Become a mediator.
Individuals are going to be replaced.
Right.
And so there is some amount of turnover in there, but I can certainly follow up with Melissa and get that more precise in terms of whether or not they budget for vacancies to be filled in any given year.
And also whether they've put in for a salary increase.
I think beyond what's recommended by this commission, I think that's the cap on what
That's the cap,
for. Or up until the end of the last commission cycle. But I will also ask that.
So Karen, can I ask you a quick question?
Certainly.
So I mean, the clear rub, obviously, and I think a number of people have noted it, is, most of us, I'd be before judges regularly because I'm a trial lawyer, and we want the highest quality people. And I know for a fact that salary is a concern. And whatever, those numbers of what people in small firms are making or not. I'm not sure all those things that you can really plug in, but most of the people that I would like to see on the bench, and I'm sure other people who were part of, in the court system, are people who are top people with a broad background, who the compensation isn't going to deter them, because we always hear that the pension and the health insurance are great, but you can't send people to school on it. You can't pay your bills with those things. I mean, so you want people who can afford to live a normal lifestyle. I mean, I think we have to, my only point, I think we have to, I mean, the chief's recommendations I find compelling. I think we don't know what's going to happen to him, though, and some of the people who are more into the political side of this, but it's going to go over there, and there's going to be, it's part of the process. Judicial, the budget they get includes the marshals, right? I mean, includes everyone in the system. So this ebb and flow of judges, we always hear there are 10 vacancies, but where does that fit in? As what you're saying, I think, is they sort of assume that some people are going to retire and some aren't. And I also think this thing about the mediators, I'm before mediators a lot. And many judges may wish to become mediators, but the people who go out in the world who do mediations in the various areas, mine is primarily personal injury and malpractice cases, it's a handful of people who I mean, we're not talking about losing everyone because of the mediators, but I think you want to keep as many quality people in the system as long as possible, because you are losing them because of this. I think we're losing them because of the salaries. And I just think that, I think that's a real concern. I think we have to be conscious of that, and we can't guess what the fiscal constraints are going to be. There are so many variables. I heard some very piercing cross-examination from Attorney Horowitz, and asking questions about about how these things fit in, and what I mean, seriously, when I know Jim quite well, and they don't know. There are so many variables, and it's part of the political process. I think we have to come up with the numbers which are going to best promote the cause, right? And then hope they survive, and hope those numbers can contribute to bring the quality judges, because we are losing people, and it's tough attracting people I would like to see with experience in the system. Right. So,
I mean, to your point, Herb, it's as much a policy issue as it is a numbers issue.
Yeah.
And I do agree that there may be some information about those 73 judges that left between 20 and 23, and maybe even go back a little further, because I think the pandemic did change the way people look at work and, staying for longer periods of time, in terms of how many years on the bench they had, how old they were when they joined. There's a number of factors, I think, that would impact how long you stay, and whether or not you stay to the mandatory retirement age of 70, or beyond the 10 years necessary to get the full pension, that factor into that. And I think also, in addition, there's not the sort of same level of people staying in one place for their entire careers, or for a certain number of years and seeing it through to the end anymore. That I don't think that exists in many professions these days, and it's probably coming later to the bench than it has other professions. I mean, you probably see it in your own law firms. I see it in terms of my colleagues who work as lawyers for the state. They're much more willing to move and be mobile than they were even 10 years ago. But the other thing that concerns me a little bit about the CPIU plus 2% is that we lose control, or the budget loses control over a factor that is unknown at the time that you agree to it, because it's factored on inflation and a whole bunch of other things. So it may be 1.5% one year, and it could be 6 or 7% in another year. And so you lose control over what the impact is to the budget.
Can I just ask a question? Does leave include retirement in the ordinary course, for whatever that means in the judicial system? Because obviously you got to weed out those who retire in the ordinary course from leaving.
I believe when the Chief Justice was asked that question, he did say that it included retirements, but what we don't know about those retirements, are they people who were full retirements or left you know, sooner than than a full retirement and just long enough to get a pension. And I think that's one of the unknowns.
Karen?
Yes.
So I think some information that we may be missing is with regards to information that could come from the Judicial Selection Commission. So since they, I guess wasn't able to participate today, I think it would be great to hear from them with regards to the factor of wanting to attract highly qualified and experienced attorneys and to serve on the bench. And so any type of data that they may be able to provide to us in terms of applicants, diversity of applicants, whether or not those numbers have gone down, if they've increased over a certain period of time, perhaps since the last report, that might be helpful to inform our thinking, particularly with regards to attracting rather than just retaining highly qualified and experienced members to serve on the bench.
Absolutely, we'll reach out to them.
Thank you.
If I may make a comment, like everyone, I think it is a top priority to have high quality judges on the bench, and I think that is something that we all strive for. I think we all feel it in our own industries, in our own roles. Everybody is having trouble with recruitment and retention, and a big consideration across the board, I do think, is compensation and increases in compensation. So a lot of the numbers that we even have to date may change going forward as our various industries are trying to increase compensation in order to attract good quality candidates. So I think that's something we have to consider as well. How that fits in with the budgetary constraints is a challenge, and Herb may be right. That's, part of that is politics, and it's not going to be something we can predict. I did take a glance, and I didn't do a deep dive, but I looked at the two past reports from 2020 and then 2016, I guess, are the ones that are available. I noticed that those commissions did not completely accept the Chief Justice's proposals in those years. And I thought that was interesting as well. And I think taking a good look at the criteria that they considered would be useful for us as well. And that was something I wanted to do as we go forward and consider these recommendations.
Thank you, Attorney Noble. Attorney Horowitz, I think you.
Yeah, I just wanted to echo what Herb Shepherdson said, and I completely agree with him. I think that there are lots of reasons why it is difficult to attract and it is difficult to retain, and I think that those of us who have been in one way or another participants in the judicial selection process have seen the difficulty in attracting people, and these are really challenging times, and the marshal's comments on that really point that out. The nature of what it's like to be a judge these days is very different than it was 10, 15, 25 years ago, where there are lots of trials. Just the whole experience is very different for them. And I think in view of that, and also to Herb's point that clearly that other people are going to be taking a look at this, and there will be pressure from many different directions on this. But I think that for us at this point, the Chief Justice's recommendations, they're not wild, they're cautious. I think that one could even make an argument that we should be paying them more in order to attract under these circumstances, a la Attorney Sterling. But in view of his recommendation, his leadership of the judiciary, the esteem which it is necessary that he be held in by members of the judiciary, the need to retain and attract judges, all of that points in the direction that we should be supporting his recommendation. And I think that it's just, there may be other political points where this is gonna get chipped apart as time goes on by others. But I think in view of what our experiences is as lawyers, as trial lawyers, and I know there are a bunch of us who are trial lawyers on the call, that's the direction we ought to go.
Thank you, Attorney Horowitz. Any other comments? And by indicating my concern, I want to be clear, indicating my concern for using the CPI review, which is a factor that's not controllable, is in no way signaling that I don't think that the salaries need to be increased. It just may be a different way. And a follow-up, while I haven't done a deep dive, I just quickly Googled the change to the constitutional officers compensation, and they actually it was from and I'll send it around. It's the summary, the Office of Legislative Research for Public Act 2285, and it ties the constitutional officers and the governor's salaries to the changes in the judiciary salaries. So the governor would be at the same level as the Supreme Court Chief Justice and Lieutenant Governor, and the constitutional officers would be the same as Superior Court judges.
Karen, can I just make one more observation? I know that this is not part of our bailiwick, and that was part of the reason why I was asking the gentleman my question, but part of the judge's experience, there's more to being a judge than the compensation. And, 20 years ago or less, there would be a marshal in every single courtroom all of the time. And we are in a climate now where judges are getting threatened, and yet there aren't marshals in their courtroom all the time. And if addressing compensation is an important factor, and I guess that's the extent of our charge, but the legislature or somebody would be remiss if they didn't take account of the entire judge's experience as being a judge in thinking about the retention and attraction of judges. If I'm a judge, I'm a 50-year-old judge, and somebody comes charging into my courtroom and they're screaming and shouting at me, and there's no marshal in the room to stand as a barrier in between that person and me, I say to myself, why do I want to be a judge? Why am I going to be doing this as a 50-year-old person? And I don't care if they pay me $220,000 or $250,000. I'm just not going to do it. And I know that we had experiences, even in my office, where because of the nature of some of our cases, we hired armed guards to stand on our floor outside our elevator so that when people got off, there was another barrier. And it is important work that we're doing, but we're addressing only a portion of the picture when we think about attraction and retention.
Thank you.
Karen, I think I come at this, I think I get to the same result, but maybe slightly differently. I don't actually think there is an attraction problem. I think if we were to get the numbers from judicial selection, I don't think we will have seen that they will have diminished substantially over time, or that the experience level will be a lot different. I think retention is probably, it would be very, like, I'm not sure those numbers would be very different either. I think you're probably seeing a lot of attrition at the higher and more experienced levels where the judges are already qualified for their full pension, maybe a little bit. But I think this is work that should be valued. And I think, and like in all other areas of civic life, serving on a school board or a whatever board, it's become just much coarser. The level of civil discourse has diminished so substantially that this work, and I think particularly about what the judges are going through when they come up for reappointment, if they've served on family dockets, and we've just seen some nightmare scenarios. And, I don't think the Chief Justice's recommendations are crazy. It bears a little thought about whether you bake in a fixed increase over time. I think that's part of the purpose of having a commission meet periodically, is to revisit whether the compensation level is. But even that point aside, I think the recommendations are appropriate. And I think, I would support them because I think since the last time this commission reported, I think there has been a marked deterioration about the quality of life from just a civility standpoint, and some of that verges on quite alarming physical danger. And I think if we don't suggest a substantial raise, then we will be valuing judges the way they were valued 4 years ago. But how difficult it has been to serve has diminished. So I think that's sort of how I come at this, for what that's worth.
Can I just make one comment along those lines? I'm not exactly sure if you look at the experience level of judicial selection. I can only talk anecdotally from what I've heard over the years, haven't been around the system and the lawyer, being a lawyer. But it does seem that there were fewer. I know when I started practice, which was quite a while ago, that there were fewer judges who had 10 or 15 years of experience, and it's more difficult to get judges. So when I see the numbers about what senior associates make, and I see what the 100 lawyer, these numbers, if I were drilling down, they don't mean anything to me. What matters is, how are you going to attract a broad background of judges, but people who have more life's experiences? And by the way, if they're a little older, they were probably making a little more money. So if you have someone who's I want to get people, most of the people are going to be, many of the people are going to be taking a pay cut, but you don't want it to be so dramatic that it's keeping people away. I know I categorically say, I've heard, there isn't a day when I have talked to a lawyer that we work with, we talk to, you'd be a great judge, to say to someone, yeah, I can't afford it. Now, they're not, if you're making X amount of dollars, 15, 20, 30% more, yeah, you're not going to do it perhaps. But it used to be that you'd attract those people. So when I hear what the senior associates are making and what a 35 to 40-year-old lawyer, I'd like to attract lawyers who have a little more life's experience, who have a broad experience in the practice of law, in whatever respective area. And it's really nice to see when there's selection that you see some people with some domestic background. I mean, you see some really good, I don't do that work, I used to. And you see some people with some trial background, with some criminal, with some civil, with all, I mean, whatever it goes with both sides, public defender, prosecutors. You like to get a broad background. And I don't want to attract I'm not looking to attract the senior associates. I really would like to get people who, frankly, who've been in the courtroom in my world, and in all the worlds. I think we want people, if it's in the divorce, and there's a lot of judges, by the way, who came out of one area and went into another and have done phenomenal jobs. I can count them many, many times over. But it's nice to have some broad experience. So the numbers don't scare me in terms of, these numbers don't scare me at all. So that's just where I'm coming from.
So I will send around, I pulled up the 2023, it's the most recent one they have available on the Judicial Selection Commission's website, which is January 23 through December 23. So I expect that they will have one shortly after the new year, but we're due to make our report then. But right now it looks like qualified candidates, 63 candidates were interviewed. As of February 1st, 2024, there are 226 qualified candidates for the Superior Court, 50 for the Appellate Court, 32 for the Supreme Court, and 1 for the Chief Justice. So, and then they do have a breakdown of the statistics between gender, national origin, and the diversity. It doesn't have years as a member. They also have years as a member of the Connecticut Bar. So I think this information will be helpful, and I'll send it to Kat and ask her to send it around.
Thank you.
Any further thoughts or discussions? I think, assuming that we get the information that we're looking for from judiciary, and they are usually very, very quick on their turnaround, we'll send that out as we get it, and I think we should plan on a work session for our next meeting.
Thank you.
Anything further for today? Thank you all very much, and I hope you had a happy Thanksgiving.
Thank you. Good meeting.
Thank you. Thanks, everyone.